I'm Saul Margo. I'm a barrister at Outer Temple Chambers, and we are lucky to be joined today by David Fairs, who is the Executive Director of Regulatory Policy, Analysis and Advice at the Pensions Regulator. And if you look him up on Twitter, he is an absolutely prolific runner of 10Ks for charity, closing in on, I think it's something like nearly 200, David. Is that right?
Not quite, Saul. I think I'm up to about 178 so far, but
wow,
yeah,
okay.
Heading towards 200.
Amazing.
All done during lockdown.
All on your treadmill.
All on the cross trainer. Yeah.
Amazing. He's kindly agreed to give us a short talk today relating to the Pension Schemes Act 2021. It's going to be about 15 or 20 minutes, after which he will be taking your questions, including those that have been sent in advance. So thank you for those. If you want to ask questions, and we'd really encourage you to do so during the talk, I can just see the number of attendees ticking up, but hopefully people are catching this. In order to ask questions, there is a Q&A box at the bottom of the screen. And if you type your questions in there, then we will try to go through those so David can answer them. You may also have a thumbs up option in that box. If you do, and you tick the thumbs up for a particular question, that promotes it up the list, and I'll see it sooner and ask David the question sooner. Please don't be shy with questions. We're going to try to get through as many as possible in the next 45 minutes or so. And finally, I think that Erica Carroll, who is the Director of Enforcement at TPR, is watching the webinar. And Erica, if at any time you want to contribute, then please let us know by typing it in the chat box or raising a hand, and hopefully we'll be able to turn your camera on for that. So without further ado, David.
Thank you, Saul. And I think this session has been a long time coming. I think originally we floated this whilst the pensions bill was going through Parliament, and it's quite challenging for us to be talking about particular aspects of the bill whilst it's still being debated within the House of Commons, House of Lords. But nevertheless, as soon as the pensions bill became an act, Saul was straight on the phone, getting me booked in, I think almost before the ink had dried on the vellum. I think recognising that Section 107 in particular and the powers have been of particular interest to lawyers and advisors, perhaps debated a little bit less within the Commons and Lords than people anticipated, but nevertheless it is an area that we recognise has stimulated quite a lot of debate. And it's always great news for us when actually things that we're involved in do generate quite a lot of interest. It gives us a degree of confidence that people are taking those things very seriously, that they're taking the time to get to understand what's being introduced. And it's fair to say that I do recognise that you and anyone impacted by the new Act are looking for clarity on the new powers that we've been given. It's important to say that the new powers we've been afforded are part of a strong package of measures to strengthen our regulatory grip and the options available to us. But they're not going to turn us into a belligerent law enforcement agency, the pensions police, if you like. You won't see an immediate uptick in our issuing of fines, prosecutions, or us pursuing prison sentences. It is our hope that the mere existence of these increased powers will further deter wrongdoers from doing wrong. If not, these powers will enable us to better tackle and punish those wrongdoers. And that's to the benefit of pension savers and the wider regulated community who are doing things right. So in short, my message to you is if you're doing the right things, you have very little to worry about. We'll continue to regulate pretty much as we have done before, living by our mantra of being quick, clear and tough. And we'll continue to guide, advise and clarify where we think it's appropriate to do so. So we'll continue to work closely with stakeholders and supervise carefully those who need particular support. And we'll continue to focus on our statutory objectives and be guided by those, and the delivery of our corporate strategic priorities of protecting pension savers. And you may see those and be very interested in the corporate strategy and the corporate plan that we're about to produce. So this Act doesn't mean that the current system is being completely overhauled. It does broaden the weapons in our arsenal, if you like, for tackling those who avoid debts to defined benefit pension schemes, or those who act to put scheme benefits at risk. We don't think it's going to change the behaviour that we investigate, although it will fundamentally change the options that are now available to us. The Pension Scheme Act, as I say, helps us build on our clear, quick and tough approach. And although it introduces some significant new penalties and criminal offences, we're not going to become a prosecution-hungry organisation. We will use the new powers in a proportionate and appropriate way. I'm going to spend a few minutes looking at a bit more detail at the Act and what it means. And it's worth bearing in mind, I think, that all the Act has been passed, the way it will be deployed is developing. An Act with so many things in it, with such complexity, doesn't emerge fully fledged. Its intent relies on organisation like ours to develop policy, guidance, codes, putting that theory into practice, and ultimately to use the powers and develop decisions with case law. And that's to say, it's going to take some time to develop fully. And so what I share with you now, what I'll run through now, is our early interpretation, our view, if you like. But we are open to change as our experience and understanding of the new powers improve. Some elements of the Act are new and others just develop established powers and themes. Overall, we think that the changes in the Act will also help us drive better standards across the schemes we regulate and better equip us to protect savers. The Act builds on the existing approach to DB funding and sets new requirements which will help trustees focus on long-term planning. It also clarifies what's expected of schemes based on their own circumstances. Regulations are being developed by government providing further detail. The Act highlights that pensions trustees should be considering the effects of climate change and will require them to engage more fully than they ever have done with the risks and opportunities that provides. A scheme that doesn't consider climate change is ignoring a major risk and opportunity to pension savings. We'll be publishing our own climate change strategy in the next week or so, recognising the new requirements brought in by the Act. New and enhanced information gathering powers, such as the interview and wider inspection power, will aid our investigations. New fixed and escalating civil penalties will mean proportionate and timely enforcement action can be taken against those who delay or fail to comply and help us secure the information we need sooner. And the Act also introduces 2 new Act tests for our contribution notice power, in addition to the existing main purpose and material detriment tests. These will look at the time of the act of failure and the impact on the amount that would be recovered by the scheme in the hypothetical event of an employer's insolvency. Call it the employer insolvency test, and the value of the employer's resources relative to the size of the scheme, so-called employer resources test. New civil penalties of up to £1 million have been introduced for the main purpose or material detriment acts, as well as those who fail to comply with a contribution notice, deliberately providing false information to us or trustees, or failing to comply with requirements under the notifiable events framework. Strengthening the deterrent in the system and giving us more options to address and punish wrongdoing. We will review and revise TPR publications that relate to funding, avoidance and penalties, including our material detriment code and code-related guidance, to include content about the new forms of Contribution Notice Act and our clearance guidance. As for wrongdoing, the Pension Schemes Act also introduces 2 new offences with a potential 7-year jail term and unlimited fine for avoiding employer debt to a scheme or behaviour risking accrued scheme benefits. This will be available to us to use where we see behaviour which intentionally or recklessly puts DB savers' benefits at risk. The powers aren't yet in force, but are expected to be enforced by the autumn, likely October. And I'm sure you all know, which is why you're here, that we've just issued our draft policy for consultation. It's worth me saying that a person can only be successfully prosecuted if all elements of the offence are shown to be met, including whether they intended to avoid employer debt to a defined benefit pension scheme, that they knew or ought to have known their act or failure would put DB savers' benefits at risk, and they had no reasonable excuse for acting as they did. Each element of the criminal offence would also need to be proved to be the criminal standard of beyond reasonable doubt. And these are high thresholds for any prosecuting authority to meet. Concerns have been expressed about the introduction of these offences, and there's been significant interest in our approach to their investigation and prosecution. And as I say, probably reflected in the number of attendees at this seminar this morning. So, in response to the requests from ministers during the passage of the bill, we have developed and published our draft policy. It sets out how we intend to approach the investigation and prosecution of these offences. We have been and will be guided by our understanding of the policy intent of the powers. And as the Minister said in Parliament, it's not to achieve a fundamental change in commercial norms or accepted standards of corporate behaviour, but to enable us to tackle the more serious, intentional or reckless conduct that was already in scope of our contribution notice power, and to increase the deterrent and punishment of such conduct. So if you haven't already, please do get involved with our consultation. We will benefit from a full range of views and certainly diverse points of view coming forward. Details of the consultation are on our website, and the consultation closes on April the 22nd. A few points to note from the draft are, we expect the new criminal offences to broadly apply to the same kind of behaviours already in the scope of our existing contribution notice powers, or that would be in scope if the person was connected with a scheme employer. Obviously, the Section 107 does apply potentially to a broader range of individuals. The introduction of the offences is not expected to change the kind of behaviour we investigate, but will be a fundamental change to the options that are available to us, where the seriousness of the behaviour warrants such intervention. When prosecuting the offences, not only will we need to show the person's requisite intention, but the onus will be on us to prove that the accused did not have a reasonable excuse. And I know that the issue of reasonable excuse is something that I know that you're very keen to know more about. And as lawyers, I think any phrase that contains an element of elasticity or subjectivity tends to bring a degree of nervousness, especially and understandably in conjunction with criminal law. So what do we, TPR, consider constitutes reasonable excuse? Well, I'm afraid given the breadth of avoidance type behaviour, it's impossible for me to provide a definitive answer. Ultimately, the courts will decide whether a person prosecuted has a reasonable excuse and will decide whether to impose a sanction. But if you're already familiar with our avoidance powers, you'll have a good idea of the things that concern us. Our draft policy includes a list of factors that are likely to be significant to our assessment. And we've provided illustrative examples from our experience of exercising our existing powers that we would consider to be in scope for prosecution. We've aimed to be as helpful as we can be in the draft policy without limiting the scope of the powers set out by Parliament. And that's a tricky balance to get right. But much of our role is a balancing act. We act as a fulcrum between many parties, savers and sponsors, employers and trustees, government and the regulated community. We've already received calls to clarify more precisely which behaviours constitute reasonable excuse. And that's going to be an iterative process, and we'll naturally develop that as we begin to investigate and use our new powers. We're already seeing a range of examples being put forward for consideration. I know you put some of those forward in terms of questions. But our view is only one aspect of it. We'll all learn and adapt in response to the decisions of the criminal courts. And as those decisions are made, we'll update our policy and guidance. So my response to you is familiarise yourself with the draft, get involved with the consultation, and in that way you can help us shape the policy. And if that's not a reason to get involved and provide your views, I'm not sure what is. One particular area which is generating quite a lot of comment is in the area of restructuring. Thinking about reasonable excuse, we understand that many employers are facing challenges as a result of COVID-19 and the impact of Brexit. Tough decisions will have to be made by some DB scheme employers or corporate groups. And those challenges would be highly relevant to our view of the reasonableness of conduct. The nature of reasonable excuse is that we'll recognise the specific circumstances the person is in at the time they take a relevant decision. If parties involved in those decisions can demonstrate they consider the impact of their actions on the scheme and either secured full mitigation for any detriment, or can demonstrate there was no viable alternative with a less detrimental impact in light of any mitigation provided, then they shouldn't be at risk of prosecution by us. Taking another specific context that might interest you advisors, whether they could give advice on what we regard as encouraging or assisting the commission of one of these new offences. In this case, as in all others, we'll take account of the policy intent behind the offences. A person will only commit the offence if they do not have a reasonable excuse for what they're doing. A professional person acting in accordance with all professional duties, conduct obligations and ethical standards applicable to the advice being given is likely to have a reasonable excuse. Any prosecution would need to meet the public interest test in the Code for Crown Prosecutors. And those of you advising in that space will only be too aware of the high threshold that that rightly imposes. And I'd like to stress again that TPR is a risk-based and proportionate regulator. This measured approach will continue with how we use these new powers. Our goal is to work with DWP, the regulated community, and wider industry and stakeholders to ensure the new measures are introduced in an effective way. We will only use these powers where it's appropriate and reasonable to do so. I'm sure you'll have some questions for me afterwards, and I'll look forward to those. I suspect some of them might be quite challenging. But I do welcome your views on how we should approach the powers, including on how we should consider whether an excuse is a reasonable one, and on our draft policy as a whole. But before I finish, I think it would be right for me to recognise the very difficult environment that we're in at the moment. So let me share with you some thoughts about the pandemic. COVID has clearly had a huge effect on the economy, on employers and on schemes, although interestingly quite diverse impact at an individual scheme and corporate level. And the impact isn't just right now, it's going to be felt, I think, for some considerable time. We are alert to the added pressures that most people are facing. We acted quickly and proportionately when the pandemic first hit. We introduced temporary easements, giving flexibility and breathing space. And we endeavour always to take a proportionate approach to enforcement decisions. And that proportionality is guided by an acute awareness of the context with which we are all operating in these challenging times. We recognise that the best support for a pension scheme is a strong employer. So it's vital that we support businesses and trustees through this crisis while balancing the risk to members and the Pension Protection Fund. We did issue last year COVID-19 guidance for schemes and employers. We allowed schemes an extension on reporting payment failures in automatic enrolment. But I think you have to recognise that there does need to be a balance. We can be understanding of the stress on employers, but we mustn't forget the saver or the Pension Protection Fund. The saver must be protected, which is why our new corporate strategy puts the saver at the heart of all our work. We expect schemes to be treated fairly by employers. We'd be concerned if companies were not following our clear guidance appropriately. It is a situation that we're monitoring very closely, and we'll continue to use our powers, old and new, to keep the saver at the heart of everything that we do. So if nothing else, I hope that what my comments just now have provided a degree of consideration and reflect the thought that we're giving to the Act. We are alive to the particular circumstances that we are in at the moment, and the breadth of the potential impact of the pandemic. And though we are the sole regulator of work-based pensions, we don't work alone. I hope your previous interactions with us as the regulator have demonstrated our willingness to listen and to learn, as well as to listen to what you have to say and think. That will always be our approach. I am asking for your input into the current consultation. Please do provide your comments by the deadline of April 22nd. Getting this to work is going to be a collaborative act between us and you. We're all responsible for the stability and sustainability of pensions and those savers who rely on us to do that. So, Saul, those are the introductory comments I'd like to make. Quite happy now to move on to questions.
Thank you, David. And I should say, anyone else that wants to put questions in the Q&A box, please do. We've got some already, including ones that were put to us in advance. So I'll start off with Julia Churnside. And David, if you can also see these questions in the Q&A box if you want to look at them. But Julia Churnside asks, to what extent do lenders need to consider a DB scheme's interests when taking a commercial decision about whether to lend to the scheme's employer group? Is it reasonable, realistic to expect the lender to consider the scheme at all?
I think so. I mean, I think there are some difficult challenges. You know, the provision of lending or not lending could have an impact on the pension scheme. The key is that actually, you know, the minister has said, and we try to reflect in our guidance, that it's not our intention to intervene in normal commercial activity. So lenders can lend to schemes, take account of the normal commercial terms, including, you know, if an employer is in difficulty and therefore by not lending, actually you may cause the insolvency of the employer, and that may have a consequential impact on the pension scheme. Then we do recognise that actually lenders do have a legitimate interest in deciding for their own commercial interest not to lend to the scheme, actually, if they don't think it's going to be in their commercial interest to do so. So I think they're going to have to think about it. They're going to have to think about the particular circumstances, but they shouldn't be driven to do something or act in a way which is not in their normal commercial interest.
I mean, presumably in terms of third parties in general, I know that in the draft policy, one of the touchstones for identifying a reasonable excuse is whether the act was, and the impact on scheme benefits rather, was an incidental consequence of the act. I mean, is that really a signal to third parties who are seeking to maximise their profits in their dealings with an employer that realistically they're not going to be in scope for prosecution?
I mean, you know, one of the challenges that we have is we've got a consultation that is open, and we have to, in terms of conducting that consultation, put out examples and then listen to the feedback. So it would be wrong for me to delve into, and I suspect we may get into some very specific examples of, you know, in this particular circumstance, does this get caught, or in this particular circumstance, does that not get caught? If I provide, if you like, very detailed answers, then actually I'm going to jeopardize the nature of the consultation that we're having. So you know, the responses that I give will be in that context. Also, inevitably, when we're provided with examples, actually in real life, the examples are always much more complicated than the ones that we can probably get into in terms of this sort of environment. So it's quite challenging for me to say, yes, there is a definite clear line, and if you act on this side of the line, then you'd be okay, and if you act on that side of the line, then you wouldn't be okay. And I think also you've got to recognise that the nature of actually what's been put in place by Parliament. So, you know, Parliament didn't expect or didn't choose to put into being a very fine line and say you can act all the way up to this line and then you'll be okay, and if you act beyond that line, you won't. The very nature, I think, of the way that this has been phrased is to allow us to be flexible, to have discretion about the types of things that we see where we choose to act. So I think, you know, probably all the comments I'm going to give around specific examples are the fact that this is a consultation, and the very nature of the consultation means we put a view forward and we have to listen to what comes back. If we prejudge the outcome of what we say, then actually we're jeopardising the nature of the consultation. I think recognise the nature of what actually has been put in place. Parliament chose to give us discretion to act. But that being said, yes, in the sort of example that you used, it may well be that actually that is incidental to and therefore not within the scope of the activities. But you've got to take account of the kind of parameters in which I'm kind of explaining those answers.
Okay, thank you. I'm going to move on to questions. They all appear as from Outer Temple, but that's just, these are the written questions that came in advance rather than just being simply from us. The question was, is TPR planning to produce guidance on how it will exercise its new powers to impose regulatory fines on companies and individuals up to £1 million? If so, is there a rough timetable? And I think Tim Smith asks a similar question later on.
Yeah, so we are going to update our monetary penalty policy to reflect the new fine. We're not going to issue detailed new guidance, but we will update the new monetary penalty policy, and that will happen before October of this year.
Okay, thank you. We may move into some questions here where you have to play a similarly straight bat, but I'll ask them anyhow. The new criminal guidance says that TPR would not expect a lender to lend if it was materially against their interests, e.g. if they assess there is a high risk of default on that further lending. Does this imply that unless it's materially against their interests, there is a presumption that lenders should lend if they can, where a DB scheme could otherwise be disadvantaged?
No, as I said before, we do recognise that lenders have got to protect their own commercial interests. So that's not the case. As I say, the intention, the minister made it very clear in Parliament that the purpose of this was not to dismiss, not to interrupt and jeopardise normal commercial interests. I think, one of the factors we could consider in assessing whether there's a reasonable excuse is the individual's purpose when acting. So we'll look at that. We'll look at any mitigation provided, and we'll also look at whether there was a less detrimental, viable alternative to the actions that they took. So those things are the sort of things that we come into being. It may well be that there wasn't a less detrimental, viable alternative to a particular action.
Thank you. Next question. Again, submitted in advance. Clearance is not available for criminal offences, but would a contribution notice clearance help to establish a reasonable excuse in relation to a criminal offence covering the same similar circumstances?
So let me be quite clear. We don't want people submitting contribution notices in order to kind of by the back door get clearance for a criminal offence, because Parliament's made it very clear that we can't clear potential criminal activity. But having said that, there is a degree of overlap between contribution notices and the areas of the criminal sanctions. So if somebody has submitted a clearance under a contribution notice and we've cleared that, then that would be obviously a relevant fact in deciding whether we would want to then pursue criminal sanction. Clearly, the people in scope of those two sanctions are different, but that may well be a reasonable excuse that people could point to, or it's not a reasonable excuse, or a relevant fact that people could point to why they did what they did.
I think I might know your answer to the next question, but this question is, in a restructuring context, to show reasonable excuse for the purposes of the new Section 58A and B criminal liability, will TPR expect to see that attempts have been made to avoid restructuring pension debt at the expense of other creditors, even if those attempts have ultimately failed?
Yeah, I mean, it's quite, as I said before, it's quite hard to give very clear-cut answers. We're not expecting, if you like, the pension scheme to trump all other creditors. In these sorts of arrangements, we're looking for the pension scheme to be treated fairly alongside other creditors. So that'd be quite a guiding principle. And it comes back to, were there any other viable alternatives that had a less impact on the pension scheme, and were they looked into? So it's a case of looking at, is the pension scheme being treated fairly relative to other creditors? And, I do recognise that actually in the heat of restructuring, sometimes these things can happen at pace, can be very difficult to do that. We're really just looking to ensure that all the parties involved in those can demonstrate to us that they've considered the potential detriment, they've tried to mitigate it if it's been possible to do so, and they've looked at alternatives.
We have got a couple of more restructuring-based questions. Again, one submitted in advance. There's been a lot of anxiety in the restructuring and insolvency community about the new criminal and civil liability. Can TPR provide any real or hypothetical examples of conduct in a restructuring of a distressed company which might be caught by the new criminal liability?
Yeah, so we have tried to do that in the policy. We've tried to show some examples of where we think there's sort of reasonable, normal commercial business going on. Equally, we've tried to provide some examples of where we think, in examples that we have seen in the past where we think it would be appropriate to take action. So we certainly tried to provide those examples. If people can have a look at those and provide feedback on them, then we'll take that into account in terms of our final policy. But we have tried to do that.
There has been a carve out from criminal liability for insolvency practitioners in limited circumstances. Do you see TPR taking steps against advisors of IPs for conduct for which the IP herself has immunity?
It'd be interesting, and I don't know the answer of whether actually IPs are protected from criminal sanctions. I suspect that may not be the case if actually there's criminal activity that is taking place. It goes back to what I was saying earlier. If there are advisors and they are bound by professional ethics, professional code of conduct, professional obligations, then if the professional follows their professional code, their code of conduct, their ethics, then that is likely to be a reasonable excuse that we would take into account.
I'm just going to skip a few, but I'll come back to them hopefully, of the questions in advance, just the ones on reasonable excuse, because it'd be nice to get some of the live questions that have been asked. Tim Smith, I think you've partly answered this question already, certainly about financial penalties. He's asked the draft enforcement policy, which has been published, does not cover the new Section 88A financial penalties and the 2 new CN triggers. Will you be issuing separate guidance on the use of these powers, and how will you decide which powers to use in a particular circumstance? There's two questions. I think you've answered the new guidance about the financial penalties.
Just in terms of the do we use criminal sanctions or do we use contribution notice? I mean, they cover similar ground, but they do have different hurdles. So to issue a contribution notice, it has to be on the balance of probabilities. It's reasonable for us to issue. As I was saying, the criminal sanctions, there is a much higher hurdle that we have to come in order to exercise those powers. And the scope is different, in the criminal sanctions, and we can use that against that don't have to be connected parties. We can use that against anybody that's involved in jeopardizing accrued benefits. So they cover similar areas, but they are different. We could choose to use neither power. We could choose to use both of them, or we could just choose to use one. And that will depend on the particular circumstances at the time and what we're looking to do. Clearly, if we're using the criminal sanction, it's because we think that's in the public interest. By its nature, to pursue a prosecution, it has to be in the public interest to actually, create a greater deterrent from that kind of behaviour being exhibited in the future.
I mean, I think those of us who've had experience of some of these, large-scale, complex enforcement actions know that often, in order to see whether the particular statutory test is met, for example, material detriment, there's often very detailed, complex expert evidence in play. Presumably, the question of whether a jury is likely to be able to cope with or successfully deal with complex expert evidence might also be a factor that determines whether it goes for criminal prosecution.
I don't know. I'm not. I think we we would have to think, what is the purpose of pursuing the action? Does the purpose of pursuing the action in itself cause a deterrent to behaviours? And quite separately, there is the probability of securing a successful prosecution. In some cases, it's quite helpful for us to pursue an action because of the deterrent impact that it has, even if we don't actually win that action.
Okay, we have more from Tim Smith. Will TPR use the threat of new criminal offences to drive a harder bargain in discussions about mitigation or settlement negotiations in respect of its other enforcement powers? If not, will you make this clear in the final policy?
I'll take that away and we'll reflect on that.
Thank you. Final one from Tim. At what point in an investigation will TPR be required to make clear if the criminal powers are in play? And could TPR seek to use explanations given or disclosures made prior to making this clear in a subsequent criminal prosecution?
I mean, I think, you said yourself, Saul, some of these are extremely complex, and quite often with these, we have to do a lot of investigation to unearth the facts to create an understanding of what is actually happening in a particular case. So when we see through that investigation that there may be the opportunity or the potential use of the powers, then we'll make that quite clear.
Our next question is actually from Dan Shaffer, although it says it's from Hugh Gittins, but I've been told it's from Dan. TPR expects schemes to be treated fairly. There is no statutory mention of fairness. Where is the TPR case team? What's the TPR case team legal basis for this? Or is like ministerial COVID guidance, or is it like ministerial COVID guidance?
I always find it challenging, not as a lawyer myself, but I always find it challenging to argue legal points with lawyers. So that may be something that I don't rise to. We are trying to be transparent about our expectations. We do have a range of powers that we can bring into force where we see that there is inappropriate activity. And that's, what we choose to do in terms of pursuance of our statutory objectives.
And I suppose, is there a risk in TPR's drafting of policy that it does introduce concepts that aren't part of the statutory scheme and that aren't then held up in the courts, I suppose? So, TPR might introduce concepts of fairness, but if it doesn't have a statutory underpinning it, is that potentially a risk, or is it just a way of indicating and giving some comfort to people as to when you're going to be pursuing cases?
It may well be the case that we try to exercise a power or use a piece of legislation, and that may fail when it goes to court. That would then be something that the government would have to reflect on whether actually they were quite happy with their outcome, or whether that was something that they wanted to think about, whether to change the legislation in order to prevent that type of behaviour happening in the future if we didn't have any statutory power to intervene or prevent it happening. That is part of, if you like, the development of policy, of seeing what the outcomes are, the extent to which legislation is currently effective. If it's not effective and Parliament wants to change that, then it has the ability to do so.
We have some welcome relief here. Darren Redmayne with a question on climate change. David talked about the importance of trustees considering climate change and notes there is more guidance in the next week or so. When TPR considers climate change, is it thinking about, one, the assets that schemes hold, two, the covenant supporting the scheme, or both?
Both. Certainly for defined benefit pension schemes, then, as I said in my talk, we do recognise that having a sustainable, profitable employer sitting alongside a defined benefit pension scheme is likely to be in that scheme's best interest. And therefore, how the sponsoring employer is dealing with both the challenge and the opportunity that's presented by climate change is going to be germane to the sustainability of the employer in the long term. So clearly the trustees have got to look at that, but they've also got to look at the investments and the impact and opportunity on investments that they hold to.
Just going to jump back to ask one of the written questions that I missed. That was quite a good one. So one of the questions put in advance, which is, in a written statement to Parliament, the Minister stated that the criminal powers would not be retrospective. The draft policy states that evidence predating the commencement date for the new powers may be relevant to the regulator's investigations. To what extent does the regulator expect to be able to look at conduct prior to autumn 2021 in applying the new powers?
So with contribution notices, obviously we can look back 6 years. So the minister has made it very clear that we can't use the criminal sanctions for acts which take place before the power comes into force, likely to be October this year. But we can look back with no time limit to actions which preceded the act that brings the criminal sanction into play. But actually, that's a two-way thing. If you think about it, there may well be some actions that an employer has taken in the lead up to when the criminal sanctions come into force, which they may want to rely on in justification of why they took the action that they did. So actually, it may well be that employers' advisors want to use evidence of their behaviour prior to the acts becoming live in October to explain the actions that they took. Equally, we may want to look at that and use that in the opposite direction. So this is not just a one-way thing. I think this is two-way. It may help both of us to be able to look at behaviours before the act it took place. But I think the intent is very clear. It's only acts or actions after October that will come into the scope of the criminal sanction.
Okay, thank you. Tim Smith, apologies. I'm just going to skip over you because we're slightly running out of time. I want to get questions in for a few other people. Susie Dakin says, Saul David, thanks for arranging this talk. Thank you, Susie, for attending. She asks, what reliance can be placed on TPR's guidance in relation to when criminal action might be taken, when this doesn't bind in any way the approach that might be taken by other prosecutory bodies? Is there any way of achieving a more joined up approach?
So clearly, we are not the sole people who can bring actions. DWP, Secretary of State, can do that too. We are socialising the guidance with other prosecuting bodies in other parts of the United Kingdom, and you would expect us to do that to drive consistency. Those discussions are ongoing.
Question from Luke Hartley, which I think you've partly addressed, but I'll ask it anyhow. He says restructurings are often characterised by the need to make decisions quickly, which can impact the ability to fully evaluate all alternatives and consider the impact on the scheme, or to engage in protracted negotiation with trustees and or TPR. Will such factors be recognised by TPR, and is it willing and able to act quickly and pragmatically in restructuring situations, e.g. in the provision of guidance or clearance?
Look, so we recognise that some of these transactions do take place quickly. The important thing is to look at all the alternatives, to document the decisions, to ensure that there's a clear audit trail. But we already do intervene very quickly in circumstances where an action is taking place very, very quickly. We do have a team that's specifically set up to parachute in to react in real time to things that there isn't a kind of a long time to reflect on what might be the best outcome, where you do have to make decisions very quickly. So we're very much geared up to do that.
Just checking, David, we're coming up to 10:47. You're okay to just go on for a few more minutes? I know you've got a meeting, but okay, thank you. Jade Murray asks, if use of criminal powers is to deter particular behaviour, why not publish more examples of behaviour you want to deter in this way? The draft guidance gives very limited examples, and many of them relate to Silent Night or BHS, reading between the lines presumably, or scenarios already in the public domain where TPR has already taken action. There is very little new information or insight in the examples provided.
Well, look, as I say, this is a consultation. We're open to feedback. So actually, if you think greater clarity can be given, then please provide that feedback to us in your consultation response. As I say, the intent behind this is to catch egregious behaviour, but quite deliberately, we have been given the discretion to act where we think it is appropriate to do so. Quite clearly, the decision was not made to provide a very clear line in the sand, such that if you put a toe over the line, then you'll be prosecuted. If you keep just the other side of the line, you won't. There is quite deliberately a level of discretion that's been retained within this, so that we can act in those circumstances where we believe it appropriate to do so.
A couple of questions that I'm going to try and take together about the look back period. Claire Rankin says, will TPR be relying on the 6-year look back when assessing conduct against the new contribution notice tests? And Samantha Brown, with a similar question, she said, could David please clarify if he was saying that the new CNs will have a 6-year look back from October 2021?
I think I'm saying with a contribution notice, we have an existing 6-year look back. The point I was trying to make is actually with criminal sanctions, there is no time limitation. I may have to rely on my colleagues to help me out exactly on the time that it's the new contribution notice. But for the new criminal sanctions, there is no limitation on time periods that you can look back. I was trying to make.
I don't know if Erica desperately wants to get involved for that final question or not.
All my colleagues just sent me a message saying the new contribution notice tests only are from October onwards.
So that suggests that would be a 6-year look back from October. Oh no, apologies.
No, you can't look back
from October 2020 onwards. Yes. Yeah. Okay, thank you. That's helpful.
Sorry, that was answered, and I was desperately trying to come off mute. Apologies.
Yes. So
sorry.
So the answer is no to the look back. Thank you. Apologies. There's a long question from Jade Murray, but I think we're going to need to draw a line under things there, David. Just wanted to say thank you so much for taking all the questions and being so open to being bombarded from all sides. It's really been an insight, and it's been fantastic to have you here. To everyone else on the call, please look out for a further Outer Temple Chambers webinar in the near future. Our plan is to bring our pensions team with its experience of existing enforcement powers together with our business crime team. We're going to look at what we can learn from what happens in the financial crime space, and in particular how to deal with the dual jeopardy of criminal prosecution and regulatory sanction, which I think is actually one of the things that a few people have been asking about in these questions. But for now, just want to say thank you to everyone for joining, and in particular, David, thank you to you for a really interesting session. Thank you.
Thank you very much.